Can the people seek a lesser included offense charge of burglary in the second degree when they only indicted the defendant on burglary as a sexually motivated felony? To find out, you have to read People versus Seignious, but it's 10 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Seignious. The citation for this case is 2024 New York Slip Opinion 00927, published by the New York Court of Appeals on February 22nd of 2024. The issue in this case is whether the people, the prosecution charging burglary in the second degree as a sexually motivated felony, results automatically in their inability to seek a lesser included offense charge of simple burglary in the second degree. I'll explain all that in a few moments. The background that's helpful to understand this case is first, burglary in the second degree under Penal Law Section 140.25 is defined as entering and remaining in a building which is a dwelling with the intent to commit a crime inside. That's burglary in the second degree. It's a felony. The next thing you have to know is that under Penal Law Section 130.91, there's something called a sexually motivated felony, which basically means that if a person commits a specified offense, completes all the elements of a specified offense, and there's like 31 or so offenses, but they commit the offense in whole or in part with the purpose of satisfying his or her own direct sexual gratification, then that is a sexually motivated felony, and there's different sentencing guidelines that apply. Sometimes they're harsher, like more severe sentencing. The last thing you have to know is that under CPL 300.52, there's a lesser included offense instruction to judges that basically says if the judge believes that this applies, they may, and if a party requests it, they must offer a lesser included charge to the jury if two elements are satisfied. First, if comparison of the elements of the lesser and the greater offense demonstrate that it's impossible to commit the greater offense without also committing lesser offense. For example, grand larceny is stealing property worth a certain amount. You cannot commit a grand larceny without also committing a petty larceny, which is just stealing property. It's impossible to steal property of a certain amount without also stealing property, okay? And the other element, so that's the first step, is comparing the elements. And the second one is if there's a reasonable view of the evidence that the jury can find that the defendant committed the lesser offense, but not the greater offense. If both those elements are present, the judge must offer the lesser included offense upon request by a party and may do it even if there's no request. Okay, so what are the facts here? The facts are that the defendant was in Manhattan outside of a NYU, New York University dormitory, and he starts groping, assaulting, and confronting various female students outside of the dorm. And he's grabbing them inappropriately in sexual ways, and the students are screaming. He grabs one person by the throat. The students run into the dormitory, and the defendant follows essentially after the students. He's confronted by security. He gets into an altercation with them. He pokes one of them in the face. Ultimately, he's subdued and arrested. The prosecution indicts him with the grand jury for several offenses, including obstruction of breathing, sexual abuse 2, and burglary in the second degree as a sexually motivated felony. They do not indict him for the simple burglary in the second degree. Okay, but you cannot commit a burglary in the second degree as a sexually motivated offense without also having committed the burglary in the second degree by definition under that sexually motivated felony statute. The defendant then goes to trial, and at the mid-trial conference, the people say, "Hey, judge, I'd like to get the lesser included offense of burglary in the second degree charged to the jury." And the defense counsel and defendant says, "No, I object. You don't get that. You charged him, and the theory you pursued is only that he entered the building, the dormitory, the dwelling, with the intent to satisfy sexual gratification. You don't get a simple vanilla burglary in the second degree." The judge did not agree with the defendant, gave the charge, and the jury ultimately returned a verdict convicting the defendant of the burglary in the second degree and acquitting him of burglary in the second degree as a sexually motivated felony. So the defendant appeals, and it goes to the appellate division, and they reverse the conviction. The procedural history here is the appellate division reverses it and says, because of the way the people presented their case and the arguments they made to the jury, they somehow foreclosed themselves to a simple Burg 2 general intent to commit a crime. They only were pursuing the theory, based upon their actions, that it was Burg 2 for a sexually motivated felony. It goes to the Court of Appeals, and here we have the holding is that they go through the differences between Burg 2, and Burg 2 is a sexually motivated felony, and they explain that you cannot commit a Burg 2 as a sexually motivated felony without first committing a Burg 2. That's one of the required elements of a sexually motivated felony, is that you have to complete the underlying offense first. And the mere and here's the important parts. They say the charge of burglary does not limit the people to a specific subset of crimes. And the only two ways that they are limited is either one, they abandon explicitly, if they affirmatively abandon the pursuit of a conviction for a specific crime, they cannot then seek to charge the jury on that crime. And here they didn't do that. So if they had specifically said to the jury, if they had said we're pursuing no other, the only intent he could have possibly had is sexual gratification, then perhaps they've explicitly abandoned it, but they didn't do that here. And the second way that they can be limited is if they explicitly identify in pleadings or in the bill of particulars or in motion practice the specific crime that they're pursuing with respect to the burglary, then they'd be limited to that theory. But they didn't do that here either. So the mere charging of the Burg 2 as a sexually motivated felony did not limit the prosecution to that theory, and they did not abandon it. And so the conviction is reinstated. The appellate division is reversed. That's the case of People versus Seignious. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.